I'm getting all like, always looking for the steeper terrain on the blues and getting kind of excited. So let's see.
Okay. I remember that all my life. So like, when I was a kid, it was like, you're on the social 8:30.
Yeah.
3:30.
Yeah.
It's just hard to pull that off.
Yeah. Well, it's just we don't have to. And that's my view. It's got to be like low pressure, just fine, right?
Yeah, exactly. It's like you got the pass, so it's like it'll be
I know. That's what. I'm so happy having ours because, like, honestly, I need about 4 hours.
Yeah.
So if I don't have to be here until 1, or I do my, I did my class prep during the Super Bowl because I didn't want to watch it.
And she was like, "Well, just turn it on."
The Super Bowl. I watched it. It was a decent Super Bowl.
No, it was actually great for a Super Bowl. I think.
Yeah.
I just
didn't care for it.
I just don't care. The Broncos, I really don't care. So. I didn't even watch Beyonce. I was like, I really like Beyonce. I thought I was going to watch it.
I watched Beyonce. I like kind of had it on mute, and then like sometimes I'm kind of interested in the commercials, and then I'll, just
there was a bad
so
one.
much money. Yeah,
they
were
were
bad.
Yeah.
But I watched Beyonce.
Yeah, she had the old crew come back out for a song or two.
Yeah.
She deigned to let them join us.
Yeah.
That is a favorite.
That's her community service for me.
That's Roland's big gig.
All right. How's it going, Alexis?
Good. How are
You're getting
you?
used to your bangs now?
A little. So very
So traumatized.
Why was there
You have to do that all the time.
Oh.
It's more high maintenance.
So they're either too short or too long, and they're like perfect for like a day. Right?
Yeah, and you're at the next, in the morning, my bangs are like,
They're cute though.
oh.
Yeah, I haven't had bangs since middle school, just because they're so hard.
That's right.
They're hard.
Well, gotta do it one time. I won't do it again, that's for sure.
Bangs, you guys don't consider having bangs.
We have bangs, don't we?
It's a great bangs.
It's free. It seems so simple, just like all these little kids that have.
Well, apparently they're really in right now, I've been told about 10 times.
Yeah.
Michelle Obama.
Yeah.
That's it.
I don't know how many years ago it was when I just quit combing my hair altogether.
See, that's kind of it for guys now too.
I hope that comes in for girls.
I like your hair too.
Oh, thank you. I don't.
You're having a hair crisis in this class.
It's just a little darker than I had anticipated, but when you tell the colorist, I trust you.
Yeah, tell me about it.
Well, great to see you guys. I'm really looking forward to class today. I'm kind of torn about whether to. We'll hand this out at the end, probably. I think since you guys are all ready to do your presentations and things like that. So I'm going to work really hard to keep my mouth shut. I just threw some ideas. The goal of this class session is to do a little survey of some of the academic scholarship that's going on right now about judicial behavior, judges, judging, just so you're aware of it, right? You don't need to become an expert in this by any stretch of the imagination, but I want to get some of the language, the terms, and the concepts out there and have us kind of understand how they relate to each other. So the only contribution I will make to structure the discussion is kind of to think about this spectrum from formalism to realism. I put critical race theory to the further end away from realism, but we can discuss if it really belongs there or not. And then these kind of concepts that one might place at different points on the spectrum in association with that basic duality between formalism and realism. So with that, I will turn it over to Alexis.
Yes.
Okay.
So I guess I decided to kind of structure this just like a discussion. So I'll ask questions and you guys wouldn't mind answering. First,
That's the tacit bargain, right?
Well, you never know when it's like, you can, when you're a student, you can also feel when when nobody's answering the teacher.
Yes.
You know,
That's the truth.
If you, maybe start with if you guys have any general thoughts, feelings of the article. I know some of the other articles were about formalism and critical race. Did you tend to agree with this article more or other articles meaning their approach to judicial opinion or judging? Judicial epistemology.
I thought that consequential, what are the words? Consequential, categorical, can kind of be, they can almost work as kind of proxies for formalism, realism in a way too, where you kind of, where categorical result is kind of more formalist and a consequentialist, just thinking about outcomes is more real, that parallel kind of occurred to me reading it.
I'm trying to find that chart that's in the.
I wish I had paper copies. And I can't get
Anytime
it.
you guys want paper copies, just let me know. I've become
I
so
should have asked
conscious
before.
about-
I was reading them off the emails, but I can't get email in here. So.
So, were we talking about the
It's
diagram?
on 49, yeah.
Okay.
I agree with you. I think that could be kind of within every single one of the four categories.
I'll recreate it for you, so.
Oh, thank you. So you were talking about the categorical consequential, which is under hypertext.
Mm-hmm.
I think that under text, the is and ought split could also be the same thing.
Yeah.
As far as what should be and what reality is.
Can you elaborate on that? Because that was something is it sort of saying, what is the is-ought distinction referring to exactly?
It's referring, let me find it in the text, it's basically referring to what what should be, what is in fact used by the population or by people, as opposed to what should be used. So what should be used meaning more principle, what invoking more kind of values as to what people think the law should be. The context with which he brings it in is under text, meaning the interpretation of the words.
Mm-hmm.
So the reality of how a word is used in a population and how it should be used, which would be according to, he calls it pre-existing criteria or normative agenda. So that would be through, so he said dictionaries. But then again, something I thought was interesting about that is the dictionary was at some point, the way it was in fact used. So at what point do you change it?
This reminds me of a kid's book, Friendle, where they make up a word and then it's like, if you use it long enough, can it be put in the dictionary,
Like impact as a non-transitive, I forget exactly what category of speech it is, but like impact, like that's impactful, or, I impacted this discussion, which used to be not okay to say that. The only time you said impact was when you were talking about wisdom teeth that were impacted. But now that's, you see it in the New York Times, right? So it's sort of that idea of, is there, and someone was talking about Wittgenstein and like, maybe not talking about Wittgenstein, but like sort of malleability of language and how certain it is versus uncertain, and then kind of transfer that to the context of judicial decision making.
Absolutely. And then, so I guess the next thing that I wanted to point out was on page 38. The author says, in contrast in Gould, which was the baseball article, and Justice Roberts, he says, despite the fact that both of them use the same regulatory concept, a strike, to make their argument, it's at the top. Professor Gould views baseball as subjective and thus like the law, while Chief Justice Roberts views the law as objective and thus like baseball. So in drawing it, what I imagined in my mind, if you don't mind, that's appreciated.
What?
Can I tell you what to? or
Yeah.
I can do it. That's great. I have really terrible handwriting.
No, that's great.
So what I had thought was, so Gould says.
Not bad at all.
So he views baseball as subjective and thus like the law. And Roberts views the law as objective and thus like baseball. And I thought that this was kind of an interesting way to compare them. Do you guys have any thoughts on what do you think the law is more subjective, or as far as he kind of talks about I guess the reasoning is inverse, which I thought was interesting. Do you think that judicial reasoning should start with the game basically, and subjectively apply the law, or start with the law and objectively apply it to the game?
I'd probably be more on Gould's side. I'm just thinking like, usually it starts with like a set of facts or an incident or something occurs, and then the law. I mean, there's always the human element and like common experiences that try and apply the law, and so like that kind of becomes the law. The objective standard, it's like, I mean, that's kind of what the law shoots for, but I don't know if it's ever like truly obtainable. I mean, without having like a numerical definition, which the law never really does, then I think it's kind of hard to achieve.
Yeah, I thought this was really interesting. I don't remember Chief Justice Roberts saying that during his confirmation hearings. I mean, at that time I wasn't really paying as much attention as I would now, but I think it's an interesting theory because I feel like, especially with the court as high as the U.S. Supreme Court, it is very subjective and very political. And so for him to say that it's objective like baseball, then we don't really need judges. Like, we could just have like computers do it, right? If you just like input the facts and input the law. But I'm not like a huge baseball fan, but I know how it works. And so I thought this was an interesting analogy because I never, like watching it, I'm just like, okay, that's a strike or that's a ball, like whatever the umpire. And I know sometimes they like, you know, the manager will come and yell at the umpire or something, but reading this article, reading Gould's article, it does seem so much more subjective than I had previously thought about, because I hadn't really thought about the objectivity, subjectivity of baseball, but I feel like it's more like the law, more like Gould too.
Awesome.
This made me think of, because I lived in Louisiana before I moved here, the difference between Napoleonic Code there and common law, the way that we practice it here, in that under civil law, like almost everything is codified, and so case law can be very persuasive, but it's not governing like it is in the other 49 states. And so I think from the Roberts perspective, it made me think more of like the civil law way of doing things, where everything is pretty much spelled out, and you can make arguments based on baseball or whatever game it is you're playing, but the law is what it is, and you can't use the current reality or past realities that are somewhat similar to say that that is the rule. And I feel like the way that things occur in the other 49 states is much more like Gould's analysis.
Something that I had thought about, kind of going to what Kira had talked about, was that if, you know, Justice Roberts is saying this and he, you know, lower courts, I think it would be more reasonable to have that approach because their application is dependent on the higher court's thinking. But when they are, I mean, the reason that cases go to the Supreme Court is because it's ambiguous or uncertain. And if his approach is one of this, then how is new law ever created?
As a baseball fan, I had a really hard time understanding where Roberts was coming from.
It's like he doesn't know the sport of baseball.
Yeah.
Or the law.
It's like, I read this book recently, Scorecasting, and they had this whole empirical breakdown of how umpires call balls and strikes, and it's totally context dependent. So the strike zone is completely different when the count's 0-2 than it is when the count's 3-0, because the umpire doesn't want to determine the outcome. I mean, it changes by like 6
didn't know
inches.
that.
Like it's a huge difference. So it's weird that his perception is like, oh, it's this box that's always the same.
And then the article talked about how like the umpire was instructed to have like a different for Babe Ruth, like, and I was like, what? Because I just thought it was the box, you know? I was like, so.
It's a productive metaphor. I think it's a really interesting metaphor.
There's so many other things to talk about. The other thing that I kind of wanted to talk about was he says that the 2 words at the end of the 5-paragraph thing, and cried, is what really determines for him the article, basically. So he says, let's see. And the author contends, it's on 84 in the bottom, that
Did you say 84?
yeah. His contention is that the umpire's tears represent doubt, not about the accuracy of the call, but about whether it was the most appropriate, most professional call that could have been made. Did he have the values right, or had he done something that would hurt the game? Which values were the more important? Those of the game in some general amorphous sense, or those of treating the individual players fairly and with respect? And he continues with several other questions. Do you guys agree that, because when I first read the thing about how he cried, and he had said that was the most important element of the 5-paragraph essay, I wrote down all the reasons why I thought he might have cried, saying that the decision was too weighty, he was stressed, he made the wrong decision. What do you guys think?
I like this, well, so a side note, but not to get too much on baseball and too much away from the law, but it just reminded me, again, my limited knowledge of baseball, but was it like just a year or 2 ago when that umpire made it was supposed to be a perfect game, and so there was like a lot of controversy because that's like a once-in-a-lifetime achievement. But I like this paragraph that you just read, because I think if a judge were to apply the law, like Robert said, just like formulaically, I think it's impractical because there are so many other factors. And I think we've talked about it in this class, but certainly in other law school classes, like if there's a criminal defendant, should you take into account his or her background and other factors rather than just what the crime was and what the statute says? Mm-hmm. So I kind of was thinking about that, but I think I like the baseball metaphor to draw that comparison, and that when you're in a courtroom, it's not just a vacuum. There's other factors that I think should be taken into account.
And along those lines, do you guys think that, or what other personal challenges do you think judges face when making, I had a legal and close decision, because that was the language he used. What came up in my mind was when I was interning for Judge Arguello, I had talked to her about the previous semester I had been with the AG's office in consumer protection. And I had worked on this case of this magazine fraud case where this family basically would target disabled and elderly people and call and sell them magazine subscriptions by saying, if they had ordered, whatever type of magazine, saying, we're with the magazine, would you like to renew your subscription, and sign them up for 5 years, or basically take their money. And the Attorney General called me when I was with Judge Arguello and said that they were arguing in front of another judge and I should come watch because it was a case I worked on. And when I went down there, the firm that I was actually working for the next summer was representing the family. And so, I remember talking to the judge about that, and something that she said to me that really stuck out was, everyone is entitled to a defense. And she was like, but in my mind, I resolved that it wouldn't be from me. And I thought that was an interesting remark from a judge. What do you guys think? I think that, I know that she's well known to be a very fair and reasonable judge, but you would think from a comment like that she would be biased. But what do you guys think?
This was after the argument or before?
I had just told her that I was going. She hadn't seen it. It was in front of a different judge.
Oh,
so.
okay.
Which makes a difference.
Yeah.
I mean, if she said it in the argument was in front of her, that would make a difference.
Yeah, definitely.
Do you think she meant like she wasn't going to make it easier for them to get off? Or
Well, she meant
just-
as an attorney because I was talking about how to line up your personal values with your
I see.
work values.
So that she wouldn't have taken the case if she was an attorney.
I think maybe she wouldn't have wanted to. I don't know if she would have.
Or maybe she's talking about her career trajectory too,
Mhm.
you know?
Mhm.
I mean, I don't know how long she's been on the bench, but
I think maybe 5 years.
yeah.
But I thought that was interesting because at the same time that she can feel that way in her personal life and how she chooses to work as a judge, she's seen as very fair and practical and has a very good reputation.
I think, just to comment on that, I think that's a really interesting anecdote, but that's this idea of what the judge projects and then the fact that they're human beings who have their own thoughts and feelings, so that she can in fact be very fair, and even if she had heard that case, she probably wouldn't have said that to you.
Yeah.
Even if she thought it inside, right? But that a judge can compartmentalize between their own personal views and then how they actually execute their job.
And so then my last, I guess, kind of question for you all was, so this, I would say, is kind of realism. And what do you think, or how do you think that this, I don't know who read the formalism articles, but how do you think that, obviously it contrasts with formalism, do you think that they can be reconciled? And same with, I know, Jerry, you read a critical race theory. So, if you guys have any thoughts on that?
I think there's some real interesting parallels and kind of what you were getting to with the normative descriptive distinction under text there. Kind of after reading the formalism and legalism and thinking about it a little bit more, I don't know that the authors presented this so much, but I think it can really be seen in a normative descriptive framework, and a few people have expressed that too with like, well, I think that formalistic view may be impractical, or that doesn't work in the real world, where there's this, well, sure, that's fine in theory, but here's the way it actually is. And I think that kind of divide is an interesting lens through which to look at a lot of these issues.
Well, and something I wonder is, I definitely have my own personal leanings, but how to keep it in check when you're a clerk, as far as, I know what I would like the judiciary to be, but as a clerk, I think that's obviously not your role.
I think that's a hard question too. What do you?
It's interesting.
Strategic formalism.
Just let me throw that out there.
Scalia.
And just going off Bill's and then Professor Pollvogt's comments with kind of with the like CRT perspective, I think, so going back to the Judge Arguello story, and like Professor Pollvogt said, judges may compartmentalize their own personal views versus what they actually do when they're, in their robe and writing the opinions. And I think every single person has biases and experiences and perspectives. So going off of Bill, I keep saying that it's kind of like impractical to just say that any one person can be completely unbiased. And so my article kind of talked about, which I'll talk about later, is like using your life perspective as a lens, which could be helpful in many situations and not always having to compartmentalize, but knowing your role and knowing that you can't just say, like you said, well, this is what I think, the legal justice system should be, and so I'm going to change it, because you're still bound by the facts and by precedent.
And I think there are a couple of Honesty and also transparency about the relationship between self and judge. Right? So it's one thing to say, I'm not relying on my own personal experience as a very wealthy, white male attorney or whatever, versus to acknowledge that one, has a particular social situation that might be part of how one thinks about conflict.
I think that's it. You guys have any questions?
And feel free to, there's a lot of interesting intersections between the pieces,
Yeah.
so feel free to, speak with each other about that, so.
Cool. All right. I'll run through some of the background and refresh your memories a little bit, then we can talk and then do a little exercise. So I did the formalism and realism articles, and they were the new formalism and new realism. So I thought I'd talk about that a little bit, and just as a general slogans that were kind of in both of them. In the formalism, it was it should be a government of laws, not men, or I guess that sounds weird if you say women. Government of laws, not women.
It's kind of a traditional phrase, so it's fine to say law and men, I think. Can you just position those?
So on the formalist end, they would want to say it's a government of laws, not men. And then on the other end, Llewellyn's slogan was kind of, it's a government of laws through men. Mm-hmm. Kind of picking up that more practical piece. Mm-hmm. So the old formalism was kind of the Langdell, in the academic sense, kind of the Langdell, like, law is science, and we can look at all these cases and come up with these scientific kind of certainty. And also kind of the Lochner era and constitutional law with sort of this rigidity and kind of extreme, rule of law, freedom of contract ideas on that end. And then it was sort of pushed aside historically by Llewellyn and the other realists, and was really kind of ridiculed for a while, where Lochner and formalism really became like bad words, where he sort of, seems like if one judge wanted to really dig at another one, he would make some Lochner reference, and that was like the worst insult you could have. And then like Scalia and some other people come along, and these authors are saying that this is a new formalism, that this is a revival of sort of this Lochner-Langdell tradition, and the hallmarks that they cite are originalism, textualism, kind of determinate rules, and kind of a structured view of the common law. But it's sort of a different formalism, and the way these authors sort of distinguish it is to say that it's now become more pragmatic, that Scalia's version is more flexible and allows for kind of more balancing between this sort of extreme rigidity and some more realism. And then if we just stay on definitions for a minute, then the new realism, we've kind of gone through what realism was with sort of that group, and the law is what a particular judge says it is. Like, there is no kind of Platonic form of this is the law, but there's that very, like, the law is what this judge says it is on this day, And there's no kind of inherent truth there as much. And the new realism, as presented in this article, is just much more about empirical studies. Like, that may be kind of your intuition that that's the way things really work, but let's put some numbers and some science to that. And came up with some really interesting things. I don't know what you guys thought of this, but they looked at the political, the racial, the gender, who appointed the judge and how how much that predicts
There's a
how he or
ton
she
of
will
work going
vote.
on in this area right now, a ton of it.
And then the makeup of the panels, which is something I hadn't really thought about before. I don't know if you guys noticed, but the sex discrimination, if there's a woman on the panel, it changes even how the men on the panel will vote on that case. Or if there's an African American, it affects how the white judges or other race judges will view kind of a voting rights case. So with that background, did you guys kind of buy on the formalism? It seemed like he really had sort of a mountain to climb with even saying this is like a coherent idea.
Yeah.
In the whole second half of the article, he kind of went through kind of surface paradoxes of inconsistencies in it. Did you guys buy his harmonization of that or no? Did you think he succeeded or think it was crap?
I thought it was crap.
Well, I feel like I'm really in the minority in this crowd.
It was like the on page.
Well, what did he
3.
say rationalize? What did he say made these somewhat conflicting or sometimes conflicting approaches to thinking about law coherent?
That you could sometimes use them and sometimes not. It's kind of what he said.
Yeah, so the things, there was sort of originalism versus textualism, conceptualism versus objectivism. And I thought he bounced around a little bit too, because one of the explanations was even, Scalia says this, but he's an outlier, so we'll ignore it. Or some of them seemed, like he was sort of dancing around it.
Yeah, or Scalia says this, but sometimes he doesn't follow it.
Yeah, so we won't really count that.
Yeah.
And
Of course, is that a shot on the author or is that a shot on Justice Scalia?
yeah. So I thought too that there was some problem with kind of the coherence of a new formalism. So did you guys, what do you think about if it's not a coherent theory, does that mean that this series of kind of viewing the law is this a way to inject politics into the judiciary while claiming that you're not? Or if it's not coherent, then what does that mean?
In my opinion, as I was reading this, and I think this theme kind of went through a couple of the articles, I just thought you can't compartmentalize this as much as all of these scholars are trying to. I would, in my view, I know the judges have different styles and are influenced by different schools of thought, but wouldn't you think, I would hope, and maybe my real beef with Scalia is, wouldn't you want to have a flexible approach as a judge and at times realize, or in situations where it's appropriate, apply sort of a more formalistic approach, but in times where, I think it was Alexa that said earlier, or maybe it was Kira, some, circumstances might warrant you sort of looking at it from a more realism perspective. I mean, if I were a judge, I would want to have the flexibility to employ both and not just be like, this is what I am and this is what I do, because you're dealing with people, not just laws. And so, I don't know, that's my opinion on it. And I don't buy the trying to merge originalism and textualism. You can't say you care what people thought in the 1700s, but we don't care what Congress thought 2 weeks ago. That to me is just a no-go as far as arguments.
Yeah.
And you did the legislative history article, right? So, that sort of idea that, well, if one is inconsistent in one's adherence to these particular approaches, that suggests that perhaps there's another agenda there rather than some sort of, intellectual or jurisprudential commitment to a particular style, right? And so I just wanted to flag too, the difference between scholars sort of saying what judges are actually doing, and that's where formalism is discredited, right? Then there's the normative piece about what judges should do, right? And that's, it's kind of interesting to think about each of these authors and where they fit within that particular question? Are they describing what's actually happening on the bench, or are they talking about the way the judges should think about judging?
And the central idea he tried to come through to in the formalism piece was sort of this independent judiciary.
Yeah.
And if you believe in realism too strongly, are you just making little legislators on the bench? And I found that kind of disturbing, because if you do go really far into realism, where the law just kind of is what that judge says it is, where does that judge get his authority? Where does it come from then?
Well, can I ask you this? Since you read these articles, like, what are judges admitting that they are realists? Are the judges admitting that there's no structure or coherency to the law, and it's really just a matter of what they feel is the correct action?
I mean, no. I don't think any judges are really.
I think all judges are saying they're, that they're formalists.
Yeah.
But the question is, are they really?
Right. So then, yeah, you almost, even if formalism is a myth in a way, do you want judges to believe it anyway? Even if it's not true, do you want them to believe that?
Or say it in their confirmation hearings?
Yeah. Because if they don't, what legitimacy do they have left?
There was a realist moment, this goes through your article, Kier, there was a realist moment in Justice Sotomayor's confirmation. What was that about? Where she kind of acknowledged realism in a sense.
Was it the wise lieutenant comments? I
Yes.
actually have that in my presentation. So
Okay, good. We'll get there then. Okay, good. Keep going.
But we can talk about that now if you want.
Well, Bill, if you have more points you want to make, I'm trying to remember what I walked up here to write down.
Just one other kind of question I had after reading this that I was interested in getting your views on is, where we have sort of this binary view of kind of formalism, realism, do you guys think that's even like a legitimate way to view the issue or not?
Well, I think going back to what Allison said is, I feel like some of these authors are making it like it's a either or, like there's a dichotomy, and maybe it's a false dichotomy, because you can still be staying true to the law and looking at precedent, but still incorporating some of these things closer to realism, like democratic, fair, active. And like we're going to talk about in mine, taking into account some personal things. But then I know Professor Pollvogt said if you're not staying true to one or the other, then what are you doing? You're just. But I don't know, I think that there is merit to not just having it be an either or. Since I believe that it's not an either or in reality anyway. So.
Right. And I thought it was really interesting in both of these articles, they really came to sort of a middle ground, where it was like the new formalism was really kind of this more moderate form of formalism and more flexible, and the new realism, the studies did show a difference, but the authors pointed out that the difference is not huge. It's, we have people all along this ideological spectrum, and yet the influences are small. It's maybe in the close cases, maybe in cases that hit a particular nerve, but it's not, you could have the most Republican and the most Democratic judge, and there's still a small difference between the two. So it's maybe not as cynical a view on the other end as we might think either.
I would just raise the other possibility that one defaults to one sort of unexamined ideology when there's a lack of reflection on it, which I've kind of talked about as being one of the real problems with both Plessy and Bowers, is lack of reflection on the assumptions that are feeding into that.
So then if we have a few other moments as the torture section of this, I was hoping we could do some really brief oral arguments, like 1 minute apiece, on some things that touch on this but might also touch on our Prop 8 how we approach it. So I thought maybe we'll just take 2 minutes and then we'll just argue 1 minute apiece. And Alexis, you argue for originalism, and Will rebut by arguing for a living constitution.
And if we run out of time, you guys will just go the next time. Everybody's gonna get to present, so.
Kira argued for bright line rules, and then Allison rebut, arguing for open-ended standards are better.
Okay.
So let's take like 2 minutes and just write down a couple of notes, and then let's go. It's like impromptu oral argument.
I love it, that's great. You're meaner than I am.
And I don't think there's necessarily, things you have to pull out of the particular articles that, I think it could be more general than
Can you
that.
restate the 4 positions real quick?
Alexis is originalism and constitutional interpretation. Will is living constitution. Kira is bright line rules. And Allison is open-ended standards.
And can I ask you another, just a clarifying question? So you want, for example, to say, in deciding the Proposition 8 case with the issue of same-sex marriage, the judges should take, or the justices should take an originalist approach because?
I think it could be more general than that at this point,
Okay.
because I don't think we have enough.
Or this is maybe, okay.
I don't think we have enough background to quite apply it.
Okay.
But just like originalism is superior because.
Okay.
How did you phrase Allison's open-ended standards?
Mhm.
Okay, thank you.
Okay, 15 seconds left.
We waste so much time.
All right, Alexis, are you ready?
Yeah.
Would you be an originalist?
Yeah. I have originalism in constitutional law rejects the idea of a living constitution because, as a principle of interpretation, through attempting to discover the original meaning or intent of the Constitution, holds true to the original intention of separation of powers. The
Good one. That's good.
Constitutionally, the principle is that the judiciary is not supposed to create, amend, or repeal laws. And with that in mind, the framers directed the judiciary and strictly limited their roles to that which is in the Constitution.
Excellent, Counselor. The clock literally stopped.
Oh, God. Do you have a clock on your computer or something? I don't have my phone with me.
Alexis's argument was just so perfect.
Okay, it's still only 4:58, so it's right for another second. I don't have my iPhone with me if I did.
Let's see, where is the?
In tools. Yeah, utilities.
Oh, there, clock.
Oh, yeah, and then down there, there's a
Stopwatch. Okay. All right, living originalism from Will. Sorry, living constitution. I mean, from.
So, Alexis made a good point with separation of powers. I mean, that's kind of a constant that we want throughout our government and throughout our, like something to be maintained in our Constitution. But the pros for a living Constitution is mostly on the social, technological standpoints. Those are a moving target, which continue to change throughout our years. I mean, at one point, women didn't have the right to vote. Another point, it was emancipation of slavery for blacks, African Americans, and then now up to date is looking at Proposition 8 and the right for gay marriage. And so these are things that, if you look at the originalist opinion, they'd never be possible. And so as our society changes, the Constitution kind of needs to evolve with it. If not, we don't advance and we don't improve as a society, and so that's the pros for that. But at the same time, having a living Constitution, we can maintain certain principles which this country is founded on.
Yes. Rules.
Yes. So bright line rules are desirable over open-ended standards because it gives judges as well as the public clear rules and standards. And there's the consistency, there's less room for interpretation. With open-ended standards, parties are unclear as to what the law is, and cases are fact-specific, so parties can't really anticipate what the outcome of their case will be. And since in our society as a democracy, people should be able to know if their conduct is illegal or if they're following the law. And with open-ended standards, they aren't on true notice, and especially because ignorance of the law is not an excuse. That's really problematic. And lastly, how can we expect judges to apply the law if we have these open-ended, fact-specific scenarios, much less juries who many times are not lawyers and have not gone to law school? There's just too much discretion.
All right, let's hear for open-ended standards.
All right. Well, I think in the spirit of separation of powers, it's important to recognize that the legislative branch is the one that makes the laws, and agencies under the executive branch create regulations, and those are a lot easier to uphold as bright line rules because of their unique expertise, I guess you could say. When it comes to the judiciary, there's an inherent amount of discretion that the judge must exercise in interpreting these rules. And someone really said that most laws create standards as opposed to rules, and so it's a lot of times up to judges to interpret those standards, and we don't want to foreclose the possibility that there is a reasonable interpretation that a judge could make. Additionally, because we're in the context of equal protection and due process, those are inherently standards as opposed to rules. And so it's important to leave certain questions open-ended because these are constitutional rights, I guess, that are granted to people, and they don't fit neatly in the box of concrete standards all the time.
All right, you guys are awesome.
You guys are all going to be, seriously, you're going to be your judge's favorite clerk. Because you guys are very, very fluid in this. That's great. That's really interesting stuff. And it's really nice too, because this is going to resonate as we work on the Prop 8 case, right? And it's sort of, there's a trust issue too. So, oh man. Does anyone remember this, The Alchemy of Race and Rights? Did anybody read that?
The what?
The Alchemy of Race and Rights. And and I can't remember the author's name right now, but she talks about sort of that one's orientation to these different viewpoints, these different approaches, might also depend on the extent to which one trusts institutional actors. And so, for me, I don't trust institutional actors, which is why I always want to push everything towards formalism so we can have a common language and there's sort of transparency about what is being done. It is the same thing being done in every case, but other people can see that differently. So that was a great exercise. Thank you.
Is that on me?
We're talking next about. All right. We did formalism and realism, and now I believe it's legislative history, law versus ideology. Will, were you rational judicial behavior?
Yeah.
I'm so psyched for you to explain that equation, and I totally didn't understand it.
Oh, I was gonna just kind of gloss over it.
Yeah, it's an interesting endpoint in terms of where a lot of this research is going.
Yeah.
And that's a good example of that. But yeah, let's talk a little bit about the relationship between ideology and legislative history, which is not something that's necessarily self-evident.
Wait, my turn?
Yeah.
Oh, I'm sorry, I thought I was going last.
That's fine.
No, I can definitely go now.
Okay.
Yeah, I think you gave us a different order
Yeah,
last week, but
well, probably did.
I'm flexible.
Okay.
I'll go, never mind. At first when I saw that I got the longest article, I kind of groaned, and then I read it, and it was actually really interesting. So I prepared a handout for everybody. Just kind of breaking down, because a lot of the article talks about sort of their methodology that they use to come to the conclusions and test the hypotheses that they had. I tried to pull out the most sort of like boiled down version of their points and what they found after looking at a bunch of judicial opinions and their use of legislative history and what that sort of means about the judges and why they use it.
And just out of curiosity, when you created this, did you find that this sort of gave you a deeper understanding? So that process of boiling down a large amount of information really helps make you an expert in whatever it is that you're talking about.
And I just thought it was fascinating because there were some things that I wouldn't necessarily have thought would have affected the use of legislative history. Like, I didn't think that it would be so obvious to everybody that liberal judges would cite legislative history more than conservative judges, but that apparently is a fact. And I also thought there's a little graph that they have somewhere in the article about the age of the statute and the frequency with which judges look at legislative history based on the age, and it's not a linear relationship. So to start off with, I'm curious what you guys think about my pro and con list here. On the pro side, we have that citing legislative history helps to discern the purpose of the enactment. I tend to, maybe it's just the fact that I'm kind of interested in environmental law and it's all very agency-oriented and administrative law-oriented, tend to think of things through the lens of agency expertise and discretion. Let's see what else. Helps judges avoid an absurd result. So if the judge's interpretation is so blatantly different from what the legislature said while they were enacting the statute, it can be helpful in that scenario.
Can we unpack that a little bit? So what is
Sure.
that? So what that means is somebody messed up. Okay, right. So either the legislature was not clear in what it articulated, or the judge was really off base with his or her interpretation, and the text is not this sort of meeting ground for those two. So there's a lot of critique inherent in that idea of absurd result.
And I thought that was interesting too, because the legislature could have every best intention of accomplishing a certain result, and if something's coming up to the court because it has, ambiguity and the court comes to a completely different result, I could see here, right, looking at the legislative history would be important to try to figure out what their intention was when they were doing it, creating the statute, if it's not obvious what their intention was. And then they talked a little, actually quite a bit about explaining specialized meanings, and so I think they said the tax code is the #1 most cited legislative history that judges tend to look at. I think partially because it's so technical, defined terms are very specific in the context that they're in, and one of the more interesting parts of it, I think I flagged it, which is they broke down the difficulty of understanding a statute. I thought I flagged it. Based on how complex it is. And it actually wasn't the IRS code that was the #1 most complex. I'm sorry.
Do you remember which one it was?
It's like some score that they gave it as two people's names. Here we go. Not usage by statute. They looked at a number of statutes based on how they were used, how often they were amended, and also here we go, the Flesch-Kincaid score on page 1700, which basically grades the complexity of the statute and what level of education you would need to be able to understand it. And the easiest being the Immigration and Nationality Act, which I thought was interesting.
Yeah.
I figure a lot of people who may not be native English speakers are interested in that one.
Yeah.
And then an Antitrust Act was like, you need 15 law degrees and all kinds of, that's a number, I think, of years of education. to be able to fully understand
This
it.
is also like a matrix of what area of law you should go into. It's desirable, right?
Exactly. But I also thought it was interesting that the Voting Rights Act was up there too.
Yeah.
Because you think of that as kind of a fundamental American right, and that particular statute's difficult on just face level to understand. So in terms of helping explain specialized meanings, I think that's what this part of the article is getting at, that some statutes just are so unique in the way they talk about things or require a really high level of technical knowledge, that legislative history can be very helpful there.
It's an interesting tie back to the whole ethical issue too, with like voting rights, and if you, I mean, just where we're talking about making things hard to understand in and of itself can kind of be on
Well,
and
I
not
think it's
putting
go ahead.
effort into trying to fully understand it. That's kind of what I get out of Varus v. Hardwick and Plessy v. Reason, like just not giving it the proper level of analysis so that your opinion makes sense to people. I found this one to be slightly less convincing, but helping judges choose among reasonable interpretations of a politically controversial statute and eliminating drafting errors the court should correct. I thought that was fascinating because I didn't really think about the courts playing a major role in that, but the authors of the article said that that is one of the less controversial reasons for something that Scalia would approve of. A reason for citing legislative history is to correct drafting errors that the legislature made. And then what I thought, because I put it on the top here, is the most compelling argument in the con category was that the congressional record contains many different opinions and statements. So it's very hard to say with any real authority what Congress as a whole, when there are so many different sub-factions and different opinions, meant in interpreting, or by passing.
And just a quick footnote to that, we'll look at Loving versus Virginia in connection with working on the Prop 8 case, but there's this discussion in there about looking at the legislative history behind the Equal Protection Clause, and was it meant to address narrow legal rights or broader civil and social rights? And the court says, we don't know the answer. We don't find it particularly illuminating. So that sort of highlights the opportunity a judge or court has to choose to rely on legislative history to one end or another, or to choose to ignore it.
Well, it's interesting to think about with a proponent of a bill gets, on the floor and makes a speech about why they want Congress to pass the law. That doesn't mean that every person who votes in favor of it shares that opinion or thinks that the reasoning that they put forward is the reasoning. They may have all kinds of other reasons that they, would vote in favor of against passing a particular law. So the no single intent portion of it I felt was very compelling. What do you guys think?
I think that's really true, and there's even they're like the bills that people propose that they know we're not going to make it, but the representative gets a certain amount of money, I think, or gets their money from the organization for just putting it on the floor. And, I mean, figuring out what their intent really is, even among the people who do talk, is really hard to know, much less the 500 different intents of, I think it's a really valid concern.
Well, and I guess next on the list we've got the idea of separation of powers again. That statement's made a lot of times. I have watched C-SPAN from time to time, which is sometimes really tragic. These off-the-cuff remarks or emotion-driven remarks that legislators can make. One of the arguments against using legislative history and judicial opinion is that those statements haven't been voted on, citing into law by the president, that there's not really a lot of authority there for the court to rely on validly in issuing its decision.
Well, it hasn't been part of that discursive process that we sort of trust to bring the best ideas to the top.
It's kind of a vetting process. Somewhere that I may disagree, I don't know about disagreeing with that, but something that came into my mind just as research assignments that I've had to do at various jobs is looking at previous drafts of a bill and specific language that was taken out in order to clarify or things that were added in. I think that can be somewhat objectively looked at without necessarily having to get into like what was the person thinking or feeling while they were doing it or putting forth language or trying to eliminate language. But I think we can talk about this more further down, but that evolution of a bill could be instructive sort of in its own way. And I'm curious what you guys think about that.
Yeah, I think the SB 10, the Arizona was like 1070 or 1040, but they changed the language of the law, which was really interesting because the way it was initially drafted was I can't think of the specific language, so this isn't that good of an example, but just like you said, looking at the change of what they had previously before they revised it really got to their intent, because the language before was a lot more discriminatory. And it was just like changing an and to an or. But I think that...
So that's interesting though, because what did that reveal? That they were trying to be less discriminatory, or that they actually were discriminatory and they covered it up?
Yeah, they got caught.
Right?
Right.
I mean, that's a really interesting question.
Yeah.
Yeah.
Yeah, I think that's kind of, it's like, even if you do see the changes, what do you make of it? Or say they really needed somebody's vote in committee, so they had to soften certain language, like then does their concession to that person become representative of the intent of everybody? Or, it's tricky, you know?
Well, you had this sort of like, it's a sausage factory view of it, and so what do you learn from looking at the sausage being made, right? That it's a lot of deal cutting, it's a lot of chaos, you know, not necessarily the reason process we might think that it would be.
Yeah, I mean, from the paper I just finished up too, it was a lot of just kind of speculative or kind of emotional stories behind a lot of the justification for the congressman. But what actually kind of drove this bill was an independent study done by like people in the market, like actual professionals, that put together the study, and their report actually provided a lot more basis for the law and created the whole framework for the bill.
Was that part of the legislative history then, the report? Or?
It wasn't really. It became part of like the House report.
Okay.
But it was considered in committee and then kind of like was posted on like the SEC website. But as far as like would the judges even look at this is kind of doubtful because it's kind of pre-legislative history. It's like what some of the congressmen looked at when drafting the bill, but they didn't really explain a lot of the measures behind it. And so once it was in the legislative history, there weren't many changes, and the justification for the changes were kind of minimal, and it got a lot more political. Like it went going through the House, they had some minor revisions, and then the Senate proposed basically the exact opposite of those amendments. Like basically anything that got rejected in the House, they put into their version in the Senate. And so, but without any justification, it was almost just like, well, since the Democratic Senate versus like a Republican House, the Democratic Senate basically put anything that the Democratic House representatives asked for, they put into their new version. And so it was very like kind of politically charged from the two realms, and it wasn't very, like if a judge looked at it, I don't think it would help him very much as far as like why did you actually propose these things.
So the two things that came to mind as I was reading that part of it was revealing the politics of it, and this goes to a point further down about the statute, I think can be helpful. I don't know about citing it as a standard of law, but the further you get away from a statute and you can look at it with some distance and see that maybe politically it was discriminatory in nature, or politically it was passed at a time where there are different political realities, whether that informs your decision as the judge, to me it seemed relevant that they could at least look at it and say, this law doesn't seem to make sense to us anymore. In the context that we're trying to apply it now, it doesn't seem to make sense. What were they thinking, at the time? And then it seems like the real divergence there is, well, then do you rely on that to help guide your decision, or do you just sort of look at it as an information source? And that kind of goes to the next one down too, that a legislative history can be easily manipulated to support the judge's own opinions. The authors of the article said that after they did this whole study and broke down all of their stats, that they didn't find that to be a huge problem. But they did note, I can't remember if it was in this article or one of the other articles, that for every person who says, oh, a legislator said this and this supports my opinion, you could make the total opposite argument. So I think because it can be argued both ways so easily, it tends to be slightly less informative to judicial opinions.
I kind of worry about it. It's just almost like where the judge almost becomes an advocate by using the legislative history for like his own arguments of how to draft the opinion.
Well, and that was one of the findings that they came up with later was that, I think it's, let's see, the third bullet point, a judge appointed by either party is more likely to cite politicians of the party that appointed the majority of the judges in the circuit responsible for reviewing their decisions. So there seems like it could be used for a little bit of pandering there to whichever circuit they're in. And then the last two, I should have put a question mark after the Scalia effect because they kind of say observers have maybe overblown the effect that Scalia has on his colleagues. In being so vocal about it, tends to draw a lot of attention to himself, but they didn't find a lot of evidence since Scalia has been on the court. The court has taken some like drastic turn away from using legislative history. But then the other one that I couldn't quite fit into a pro or con category, so maybe I just put it in the con category to make the table nice and neat, was judges citing legislative history can affect the way that Congress writes statutes in the future. And I was wondering if you guys could help me put together some pro and con arguments for that, maybe in light of separation of powers and judicial activism.
And what it, when you say adversely affect, what do you see as the big?
Well, so the column that I came up with is Congress intentionally going to leave any ambiguity whatsoever? I know that
Where it becomes so long.
Yeah, that the point, obviously a goal with crafting a statute is to try to eliminate as much ambiguity as possible. But are they going to take it to such an extreme that laws become, so long and complicated and have every, thing spelled out such that there's nothing to interpret? Is that a negative?
That's what I was kind of thinking about too. That's why I wanted to see if you were on the same page. I was thinking about like the Commerce Clause stuff where it's like, you have to have all of this legislative purpose and stuff to link one to the other, so then Congress starts producing these giant factual prefaces as part of their legislation. What does that really, I don't know that it's really inherently bad either, but what purpose does that serve other than they're kind of bloating the legislation?
I think it could bog down the legislative process a little bit.
So I guess a private law sort of metaphor for this is drafting contracts versus contract litigation, okay? The difference between, prospective writing, thinking, and, retrospective deciding conflicts that have already arisen. And so there's this balance, right, between detail generalization, right? That you're alluding to there, and that this might become sort of burdensome. But as between having a legislative history where purposes and sort of information sources are explained versus not, arguably the former is a little more democratic. At least you have something to argue over. At least you have Congress saying exactly what it's doing and why. One other just quick thought about that communication between the judiciary and the legislative branch. If the court comes out and says, well, if you have an exhaustive list of conduct that's covered, then we're going to assume anything not listed there, right, is not included. That actually helps the legislature in the future to communicate more clearly to the judiciary what they're trying to do. So in a way, maybe it establishes some principles or standards that are helpful to the communication between the two.
Yeah, maybe that shouldn't be in the con category. It was thought-provoking because then I thought, I did think, kind of like Bill was saying that, I think it could be detrimental to have statutes grow exponentially in length just so that the judiciary doesn't have to take any look whatsoever into what they meant.
And is that possible? Is that even conceivable?
And how does that help an average person understand their rights? I mean, really, it could have a negative impact on
Well, even like with contracts, right? I mean, I drive contracts that, are a page long and people flip out. They think they should be 30 pages. And can the average person understand that 30-page contract? No, not really. So there's a tension.
And I think you were right that, like you said, it should probably be in the pro and cons. I think it cuts both ways, and especially with the contract drafting example. It's like, do you want to just like throw the kitchen sink and have all of us spend like weeks brainstorming every single little thing to put into the contract? Because that kind of becomes counterproductive at some point. But it also might serve to prevent litigation later.
But it doesn't.
I'll find something to litigate over anyway.
And as lawyers, we're supposed to celebrate the ambiguity, so we want to keep those statutes short and sweet. Okay, well, I won't go over every bullet point in the bottom here, but I thought I'd ask everybody what they found to be the most surprising finding from this study. And I can start by telling you guys mine, which, well, maybe not surprising, but most interesting, which I think I mentioned earlier, was one that liberal judges are more likely than conservative judges to use it. And because I naively was like, well, they'll just use it when it's useful to them. I mean, is it really political like that? But the article seems to suggest that liberal judges tend to fall more on the realism side of the spectrum, and that conservative, very formalistic judges tend to want to look less at sort of ambiguous or conflicting statements by the legislature and just go with what's on the paper. So that was an interesting way to break it down, I thought.
Which of those do you think, I'm not trying to interrupt, but it's just such an interesting point. Like, which of those orientations by the judge is taking on more power, right? Mm-hmm. If you say the text says what it says, I'm going to tell you what it says. Is that the bigger power move? Or is the bigger power move to say, I'm not saying this, members of Congress said this,
Right.
Or which is more valid?
What you're saying.
Yeah.
I think, in my opinion, looking at legislative history and exercising judicial discretion and how to use it, how to cite it, what it means, and then saying, Congress thought this, and now I either think this or I don't, that to me seems to be taking on more authority. And not just saying, that's the word on the page, and that's what it says. So we just have to go with that. So it's definitely an interesting power struggle.
I think there's interesting intersections between kind of politics and personality, too. Heard some things recently that if you know kind of people's personality, you can predict a lot of their political... and a lot of it can even just be about, like, desire for control and predictability, and like conservative in a more general sense really does align sometimes with conservative in the political sense, and also that this was from the Well-Dressed Ape, but people who are more repulsed by other people's behavior tend to be Republican in this country. People who have a more emotional reaction to groups that they're afraid of.
Like the legislature?
1 minute oral argument.
Well, Bill Estridge talks about that, about the role of sort of disgust and repulsion in, the response to gay rights movement and things like that. It's interesting to think about as a political correlation. I hadn't thought about that before.
Anyone else have any thoughts on what was most
What about the
surprising?
dissenting
Yeah, I was
concurring
curious.
opinions?
Oh,
sure.
I was wondering.
So what they talked about was that because majority opinions are the law, they may tend to want to take a slightly more thorough approach and look at legislative history, whereas with dissents and concurrence, I think it was dissents after that, and then concurrence was at the bottom of the list in terms of the frequency with which they cited legislative history. The author said that that's either a product of the judge or justice just knowing that it's not creating law, so maybe they're not going as much into the history of it, or that a dissent or concurring opinion may be, or generally tends to be in response to what the majority has said, and so if the majority has already covered it, unless there's some really compelling argument on the other side of the legislative history, they just tend to be less likely to delve into it.
I feel like the unanimous, that it's no more likely unanimous than a non-unanimous kind of goes to like trust and like public perception of the judiciary, because that kind of surprised me. But just because all 9 of the justices agree, they still want to back it up, I guess, and showing that this is what the legislators intended to.
Well, and I also think it goes to if, I thought about whether a decision's controversial or not. Like, you would think that a unanimous decision would be slightly less controversial in nature than a not unanimous.
It's the opposite.
Yeah, and so.
The courts want to go per curiam when there's a lot at stake.
I would have thought if it's a non-unanimous opinion, then they're going to be digging deeper into it to try to discern the meaning because the justices don't agree. But it was kind of a wash there. I think there was no statistically significant difference between those two categories.
Hey, this was a great class, guys. I really enjoyed this a lot. You did a really good job. And if it's okay with you two to continue on Wednesday. And Will, why don't you plan on going first? Because I think, Kira, your article is a sort of like exemplar of this trend and view of realism or what have you. And then I think your article brings in some overarching themes that we can kind of talk about as a nice way of wrapping it up. No reading. I'm just going to give you this one little piece that I thought was, I love this article and I think it's really amusing. But it's Pierre Schlag talking about this sort of pseudoscience idea comes in, but it's sort of talking about, he's comparing law and phrenology being the study of bumps on the head, and saying that they're basically equivalent in terms of their intellectual structure, and that it's sort of, we choose to believe because it works for us to believe that these things are, kind of larger truths, even if they're not. So I thought that was kind of an interesting little caveat to what we've been talking about. So no additional reading for Wednesday. What we're going to do Wednesday is finish up with your presentations, and then we're going to talk about the procedural stuff, jurisdiction, post-trial motions, preservation of issues, all that good stuff. And then we're going to give you the district court decision in the Perry case, and we're going to start to get to work on the problem. So that's going to be a lot of fun, I think. Really, really nice job today, guys.
Excited to talk about your article there.
Yeah, me too. Bill, you provided a brief for my and then argue it.
Upping the ante.
No more than 40 pages.
Yeah. More than 40 pages, single space, blue book, wiki.
Crazy.
No more arguments for just a monologue about what I think. That would be.
Impromptu, there's no pressure. No expectation.
I know. You have 30 seconds. Well, I was like, it was really helpful, and it'll be really helpful for property, but it's stuff that we also have previous knowledge about, It's interesting for Professor Leon's term class, we talked about standard versus the whole class. I thought it was a data policy question, but it wasn't.
On her exam?
Yeah.
I never thought of standards and rules being particularly dichotomous, but I know that's sort of they're more kind of things that work together, but it's a big debate in the academy.
I kind of think of it particularly in the context of administrative agencies, they're given standards by statute and they have to make little rules into the regulations.
Now remind me, you talked about Hobbes and legislative history before, and I can't remember what you said.
I just wanted to read that article because he tends to be really about looking at both
He's really
history
into it.
and legislative history.
Do you know
I guess.
that from reading his opinion, or did he tell you? Or how do you know that?
Both.
Yeah.
He just really, I think it's
I know
more
he's into history.
history. And tends to kind of look at legislative history as a product of that, to try to get the full background picture of where things come down. And I think part of it too is because he was a water law guy. Water law is you can't divorce it from the history of the settlement and development of the state and who the major, municipal versus agricultural entities, and it all is really tied to history. And so I used to really like it. There's actually an
And you love it too. I just thought you were so excited about that.
Issued an interesting opinion today about City of Blackhawk tried to disallow bicycle riding on certain streets, And he issued an opinion today that I read briefly at work that basically said that they were preempting state regulations because it was an issue, a mixed issue of state and local concern. And he went into a really long history of the settlement, the Black Hawk area. You know, I don't know how much it